Hi there, I'm Seb Maley from Qdos, and in this video we'll take a look at the government's Employment Rights Bill and how it could impact contractors, freelancers and the self-employed. The Employment Rights Bill stems from Labour's pre-election manifesto, which was launched back in 2024. They set out a plan for change, which promised to address the stagnation of wages, reduce insecurity in work, and what Labour felt was an erosion of employment rights. Naturally, being Labour, they also pledged to attack this from the bottom up, focusing on working people and recognising them as the pillars of our economy. The key promise from their plan for change was to make work pay, which had a central theme of rebalancing power in the workplace. The umbrella of make work pay effectively acts as the delivery mechanism of employment-related measures within Labour's overarching plan for change. The manifesto set out several areas of focus, including a ban on zero-hours contracts, day one rights to protection from dismissal, parental leave and sick pay, and the establishment of a new Fair Work Agency. As part of their manifesto, Labour made the promise of introducing new legislation within 100 days of them being elected into government, which, as we know, they succeeded in doing in July 2024. Indeed, they also upheld this promise by launching the Employment Rights Bill on the 10th of October 2024, which was then followed by drafting, debate and stakeholder engagement. At this stage, there was still a lack of clarity around the specifics of the bill and, importantly, the timing for implementation of its various measures. On the 1st of July 2025, however, the government released a formal implementation roadmap which very clearly sets out exactly what will be introduced and when, giving a level of certainty on how much time people and businesses have to prepare. So now we have this clarity, let's have a look at how the bill is going to impact flexible workers. As you might imagine, being a bill focused on employment rights, there's very little in it which directly impacts the self-employed. There are, however, two key issues that people involved in the flexible economy were keeping a watchful eye on. Firstly, we have the area of worker status, which is an issue Labour started highlighting long before they took power. The UK has a three-tiered classification system with employees, the self-employed, but also Lim B workers, who effectively sit in between employees and the self-employed. There's been an explosion in the number of people in this third worker category due to the rise in the gig economy and various high-profile court cases. Labour's view was that this adds a huge amount of complexity for both employers and workers, but also leaves those in the Lim B category in a bit of a no man's land with far less protection than employees, but also an absence of the freedom and flexibility afforded to the self-employed. Their view was that the third category should be removed in its entirety, and they tabled this way back in 2021. It was included in their Green Paper a year later and then featured again in their pre-election manifesto, as well as in their Next Steps document, which was released once they entered government. It was therefore a little confusing that it wasn't then mentioned in the Employment Rights Bill when it was originally released in October 2024, although the government continued to make noises that a consultation would be forthcoming. In fact, in June 2025, they released a document focusing on the creative sector, which highlighted the importance of the self-employed and specifically referenced that a consultation on worker status would be imminent. When the implementation roadmap was released a few days later, however, the issue was once again conspicuous in its absence, which led observers to question whether the government was simply brushing it under the carpet. The reason I am disappointed in this is that the potential for reform in this space extends beyond merely simplifying the worker categories. In any form of simplification, the government would need to address exactly how a distinction between employee and self-employed is made. In recent years, making this distinction has become virtually impossible, and it's one of the reasons the reform of IR35 had such a catastrophic impact for contractors. Companies who had the new job of determining their status simply could not cope with the complexity of the decision, so often made risk-averse decisions simply to avoid using self-employed workers. That risk aversion leads neatly into the second point of relevance in the Employment Rights Bill, which concerns umbrella companies. The fallout of the IR35 reforms pushed tens of thousands of contractors into umbrella companies who act as an employing intermediary between contractor and agency or client. The issue with umbrella companies is that for over 20 years the sector has been plagued by tax avoidance schemes who dress themselves up as genuine umbrella companies but ultimately peddle contrived mechanisms which aggressively avoid tax. This was recognised by the previous government, who opened a consultation prior to their displacement by Labour, but Labour have very much picked up the baton and really honed in on the umbrella market. Prior to the implementation roadmap, we already knew that new tax legislation was incoming in 2026, which will make recruitment firms or clients jointly and severably liable for any tax deficit if an umbrella company is involved in the chain. The government has doubled down on this though, and the implementation roadmap has confirmed that umbrella companies will also be subject to formal regulation. We now know that a consultation on this regulation will be launched in late 2025, with regulation taking effect at some point in 2027. Many people see this as a positive move, particularly contractors who have been targeted by contrived schemes in the past or simply want greater certainty that their affairs are being handled compliantly. The majority of umbrella companies have also reacted positively, although the key for them will be in the specifics of what regulation means and the need to avoid knee-jerk reactions like we saw with the IR35 reform. There is, of course, a huge amount more detail to come, and we'll continue to keep you fully updated. Please subscribe to our channel or reach out if you have any questions, and we'll see you next time.